John Howell.
Thank you, Madam Deputy Speaker, and it's a great pleasure to follow the Honourable Member for Bristol West, not least because, like her, I'm not a lawyer. And I think the more non-lawyers that speak in this debate, the better it will be for that, because we bring a common sense to this debate, which I'm afraid, from time to time, those members who are legally qualified do not. I was, however, completely entranced by my honourable friend's description of justices' clerks. And I thought that my opportunity had come now, because these were non-legally qualified people that had a role to play, and I thought this is an opportunity for me when I finish here. But sadly, even that has been taken away. I do, if I can just pick up on one of the things that the Honourable Lady mentioned when she talked of other things distracting from our examination of this sort of area. I think this is just the sort of bill that we need to concentrate on. I don't think that this is I don't think we should be distracted by other things. I think this is one of the things that we need to concentrate on, because I do think it is crucially important to the management of justice and to the management of our courts. Of course, I'll give way.
Thank you. Very kind. I just wanted to clarify my point about members being distracted is my concern, because I agree with him. This is exactly the sort of bill we should be focusing on. That members are distracted by the wider constitutional impacts of that word beginning with B that I won't mention.
Members are distracted by that, but I am incredibly pleased to see that neither she nor I are going to be distracted by it, and that we are going to concentrate on the terms of this bill in a very big way. I mentioned in an intervention on the Lord Chancellor that I had earlier been actually the first Member of Parliament to go on the Industry and Parliament Trust Fellowship in Law. And that was a particularly enlightening experience. I can't remember the number of days that I'd been allocated, but I doubled the number of days that I spent on it, because you spent most of the time sitting alongside judges on the bench, listening and hearing to what they did. And the number of courts that I saw in this was really quite tremendous. I remember starting off in the commercial courts, and I'll come back to the commercial courts in a little while, because they have such a technological advance on all other courts that I sat in, that it was a really good thing to see there. But I go back to the point that I made to my honourable friend, that one of the things that came out of that experience of sitting alongside judges was firstly my absolute admiration for the integrity of judges and the integrity of what they did and how they did it. The second thing that came out of it was an understanding of how overworked they are. We tend to think, as non-lawyers perhaps, of judges just turning up and sitting and listening to the case and giving judgment. But the amount of preparation that goes into those hearings is phenomenal, and it was a very good thing to see and to experience. That applied whether that was the bankruptcy court or whether indeed it was the Court of Appeal, which I sat in on 2 occasions. And the point that I made to my honourable friend earlier is about the speed of justice. Now, I'm not a great advocate of speed in itself for this, but I do think that English law does have a threat, and that threat is not Brexit. That threat is the ability of our courts to be able to dispense that justice on a timely basis. And what I saw when I was sitting with judges was that they were often so preoccupied with the minor administrative elements of their role as judges that they didn't have time to dispense that justice in what I would consider a timely manner. And that was the case whether I was sitting in a higher court or particularly whether I was sitting in a tribunal. And I'll come back to say something about tribunals in a moment. But I just return to the point that the efficiency of giving that judgment, the efficiency of being able to deliver English justice in those circumstances is one of the hallmarks of the justice system in this country, and it's one that we lose at our peril. And I think that if that point alone is made, then it is made well. There is an issue too that I would like to raise that may at first not seem immediately applicable to the bill, and that is the age of judges. But I believe it is applicable to the bill because here we are looking at other functions for other judicial functions, people taking those judicial functions. But the age of judges, and I know it was raised in relation to the magistracy, but it applies also to Lord Justices and to others. Now, in the Justice Select Committee, we had the Lord Chief Justice before us, I think it was last week, and we asked him about the age of justices, and he did explain that there were mechanisms by which they could be extended beyond 70 in certain capacities. But I do think that that is an artificial cut-off. If we were to be stopped at 70 from being MPs, I think there would be a lot of shouts of horror. Because some of us, and I'm nowhere near that age now, but some of us would consider that we were being cut off in the prime of our life. And I think that that is the case with judges. They have acquired a tremendous amount of experience, principally as barristers. They've had a lot of judicial experience, and they're just coming to the point where they can use that experience in the best possible way. So I do think that it will be necessary to look at extending the age at which judges retire beyond 70 and to be able to look at the courts in a holistic way to be able to do that.
Well, my friend,
of course.
I'm very grateful to my friend, and he makes the most important point, because I'm sure he will know that the coalition government increased the age at which members of the public could sit as jurors to 75, and it seems quite bizarre that a layperson fit and healthy and willing to serve can sit as a juror up to 75, but you can't sit as a judge of the High Court or the Court of Appeal or the Supreme Court, unlike in the United States, where, of course, they can go on to a very considerable time.
Well, I'm not sure that I would like to follow the experience of the United States in much of this, but I think my honourable friend makes an absolutely first-class point. There needs to be some consistency in this. There needs to be some consistent approach to the age at which we can either use people or not use people, where we force them to retire. So I think there is a lot to be said for the system that is used within this bill for using people to undertake some of the activities that judges used to undertake. And just as an aside on that, I said I was a non-lawyer, but I am actually seeking at the moment to extend my ability to undertake arbitration. And I hope that doesn't cut across what I'm saying or invalidate what I'm saying, but I do think that is an important element of this mix, which needs to be taken into account in looking at the judicial system as a whole. Now, while I was involved in sitting with judges for this fellowship, I was very much aware of the difference in the digitisation and the technological aspects that were there within the courts. In the commercial court, the system was utterly brilliant. I sat with a judge who was listening to a case in Portuguese. It was an English law case in Portuguese. but where the transcript of the English translation was almost instantaneous on his laptop, on his desk in front of him. And I thought that the use of technology there was just absolutely fantastic in terms of getting the information out and getting the information across. But when you came to something like the employment tribunals that I sat with, as I said to the Lord Chancellor, you might as well still have been using the quill pen. It was such an antiquated way, not in terms of the judgment itself, but in terms of how the courts were organised, how they delivered that system of justice. And I do think that if we're talking about access to justice, the digitisation process that is taking place within the courts is absolutely essential to see through to the end, because I do think it materially influences access to justice. And there were issues too in the Court of Appeal, when I sat in the Court of Appeal, where prisoners were trying to appeal their sentences, and it was clearly not a good idea to bring the prisoner into court, and their video links were used all the time in the Court of Appeal to great effect in being able to take forward the judgment that was being given. There were some discrepancies with that. It took a bit to get the focusing right on some of the prisoners, which I take it was due to the camera equipment rather than the features of the prisoners. But when I started my work as chairman of the All-Party Parliamentary Group on Alternative Dispute Resolution, I had the opportunity to speak with Lord Briggs about what he was proposing for the justice system as a whole. And what we have here, of course, is something that moves us closer on towards what Lord Briggs was after, but doesn't take us all the way to it. And the digitisation of things like divorce is to be welcomed. But his proposal for online courts is a very valuable thing to be added to. I know it is a controversial aspect amongst lawyers, but I do think it is important for being able to deliver justice and for keeping that issue of access to justice. I would also like to see that process extended beyond the courts, beyond the scope of the current bill, so that we can receive and transmit electronic evidence in the handling of individual court cases. And I think that anything that can move the legal profession into the 21st century in doing this is to be absolutely welcomed. So if I can give a plug for the Industry and Parliament Trust Fellowship, having been the first to go on it, I would absolutely do so. I think the experience of sitting with judges alongside them is absolutely first class. I remember on the first my first appearance in court, if you like to put it that way, was in the commercial court, and I went down with the judge to his court, and was just about to go through the door, and I said, right, I shall just go round the back and sit at the back of the court now. And he said, what do you mean? What do you mean? You're sitting up with me, next to me, in the court. Well, I mean, it was a great shock to me, but it was a particularly...
Great shock to the defendant.
It was a great shock to the defendant, my honourable friend says. It was actually a great shock to the barristers who were represented there, particularly when I sat in the planning court, and it was a well-known barrister to me, and we did play a little trick on him of coming in through different doors so that he was unaware of who we were. But the point of all of that is that it is a very valuable court, a very valuable training scheme, and the more that people can go on it, the more there will be an understanding of issues such as this, of the issues that have been raised in the bill, and of the need to bring the courts, as I say, into the 21st century.